hey, I need you to sign this paperwork. Stay tuned to learn what you need to watch out for before you sign your new apartment lease. It's usually something scary for a lot of people. Some people shy away from contracts and they say, the moment I see a paper, I ask, where do I sign? That's not a rule you want to follow when you have an apartment lease to sign. Do take a look at it. You may as well get familiar with them because you will continue to see them until you become owner of a property. And they can vary contract to contract. Not everybody will be willingly talk to you. Some will strictly enforce it, and you don't want to be caught in a fight that can cost you a lot of money. The first time that you read this will be when you're being charged money or money was deducted from your security deposit. So take the time to read a lease at least once, review it, familiarize yourself with it, so that in the future, as you see terms again and again, you will know what's important and what's typical of a contract from one to another. The whole point of this is to educate yourself, be smart, save money, and not get yourself in trouble. So let's get started. Today we're gonna go over a standard residential apartment lease. First of all, you expect to see the date that the contract was signed, who the parties are. Here we have the property owner, the tenant's name, contact information, property address, and what unit is being rented. Specifically included should be a description of what's included in the apartment. So for example, here we have a 2-bedroom, living room, kitchen, and 1 bathroom. The lease should specify how long the lease will last. Now there's a difference between a month-to-month lease, which simply means you're putting in writing the terms of renting an apartment, versus a lease that can be any term. It can be 2 months, it can be 2 years. But the most standard that people follow is 12 months. It'll specify when it starts, when it ends. I've mentioned before, see if you can get it to be the first to the first. It is always awkward to have to move on the 31st, but your new apartment will not be available until the 1st of the following month. Moving forward, the lease will state that the rent is a fixed amount for the following 12 months, but payments will be made on monthly installments. Here, $2,000 paid and due on the 1st of each month in advance. When you're paying for the first, you are paying in full that next month that you will be living there. This standard lease has a tax escalation clause. Simply stated, the rent is based on current taxes, and it specifically includes language that says if the base real estate taxes were to increase by X%, rent could potentially increase. Because this clause does not apply, we've simply wrote NA or not applicable in each section. But there's absolutely nothing wrong with a big X going through the whole section if you want to ensure that anything that doesn't apply to you is clearly noted on the contract. Further down, you will see contact information for maintenance and repair requests. It will have the name, phone number, and address of who you should contact. Assuming it's urgent, you're very likely to need either an email or a phone number, because by mail definitely will not work. Additional provisions is something that is generally left open, and the owner is the one that will usually throw in a few restrictions or requirements on behalf of the tenant. Here we have that trash is to be stored in designated receptacles, and each tenant shall put out the trash barrels each week at the curb for pickup. Tenants shall be solely responsible for snow and ice removal from their front door. That means their entry door. That would only apply if you have a unit that only has a door to you. Otherwise, if the same door leads to multiple units, unlikely that one unit will accept responsibility unless you're getting a discount or some sort of better rate. If there's parking, sometimes it'll be included. Here, rather than mentioning parking, we're restricting parking, saying tenant is specifically prohibited from parking vehicle in driveway and must use the street parking and obtain a residential permit if necessary. Heat and other utilities. This clause specifies what utilities the tenant will be responsible for. There are some leases that will be inclusive, meaning all utilities are included. But if that's the case, the owner will usually insist on a higher rent because they're taking the risk that the utilities may not be used, but at the same time, the utilities may be abused. What do I mean by that? One easy example is keeping the heat at an extraordinarily high temperature during the winter months. Of course, this implies two things. One, that it actually works, and two, that it can be costly. On the other end, the tenant can simply accept responsibility to pay utilities, but it comes with the condition that that can only be done if the utilities are exclusively limited to the unit that you live in. Very rare to have utilities that are shared by more than one apartment. But if that's the case, be clear that it is indicated in the lease so that you're well aware of what you're getting into. So general utilities for any apartment include electricity, cable, telephone, heat, gas, and if you like to watch TV, cable service, satellite service. The leases will generally state if there's any other forms attached. In this case, I wrote none, but make sure that if anything's referenced in the lease, you also ask for a copy. Plenty of times where people say, see referenced house rules, see referenced additional terms and conditions. If you do not get them and sign this, it's assumed it's part of it. Although the better rule is to ensure that any document which you intend to apply to you must be signed. You could include that yourself as a term on the lease to ensure nothing is thrown in there without your consent. Care of premises. You're promising the owner that you will take care of the property in a regular manner. No abuse will occur. Cleanliness. You will take care of the property so that it remains in a clean condition, in sanitary condition, removing all trash and not keeping it in bad condition that would be out of the ordinary for most people. The lease then provides some definitions just to explain that the leaseor refers to the owner and the leasee refers to the tenant. If the owner cannot deliver the apartment to you at the beginning of the month, but you still desire to rent the apartment, the owner can prorate the rent based on how many days late he is delivering it to you. So if you got it on the 15th, because it's half a month, the rent can be adjusted to half the month. Basically, the rule is prorated day to day, eminent domain. An extraordinary clause unlikely to be used, but it simply means that if for any reason in the future the government were to seek possession or ownership of the property and in effect take title from the owner faces no liability from the tenant due to the tenant being forced out of the unit. I are another casualty. The owner makes it known to the tenant that they may have homeowners insurance or liability insurance, but it is for their sole protection. If the tenant requires insurance on their property, the tenant can buy tenant's insurance, which protects loss of the personal property the tenant has. Please be very careful because many people think that they are protected by the owner's insurance. They are not. And tenant's insurance is quite cheap. It can cost you $120, $150, no more than $150 to $200, I would say, for coverage of anywhere from $20,000 to $30,000 in personal property. If you suffered a loss, that doesn't mean the insurance will give you that much money. That's just simply the cap of how much property value they're willing to cover. You would still have to demonstrate that you in fact had property that equaled that value, and the best protection you can have is just to have photographs or keep receipts of whatever you purchase. Disturbances Illegal Use. If you cause significant disturbance, which in legal terms is called a nuisance, to either the owner or other neighbors, the owner can consider the lease to be in default, and that would be a basis to try to end the lease and kick you out. Both the owner and the tenant agree to comply with government regulations regarding upkeep of the property. Basically, you understand that it would be unlawful to conduct anything that is illegal in the property. This lease specifies that no receptacles, vehicles, baby carriages, or other articles or obstructions may be placed in the halls or other common areas of the passageways. Some people like to use the hallways and space outside their apartments. but the rent's actually for only the interior of the unit, and for safety reasons, it's prohibited to leave anything significant outside that could impede a person's ability to enter or exit under an emergency. I already mentioned insurance, so please make sure that if you're going to rent a place, consider buying insurance. Locks and keys. The lease prohibits a tenant from changing locks and keys, but if you do want to change locks and keys, you can reach out to the owner and they're happy to do it, and they will charge you a nominal fee. In addition, if you did in fact change the locks and keys, you would be subject to charge to replacement of locks and keys so that the owner can have access to the property. Loss and damage. If the property use is limited or restricted due to a loss or damage, for example, a house fire, the lease is not necessarily breached, but of course you would be under no obligation to pay. But here the problem is you would need to find somewhere else to live, and that would be a problem. Loss and damage. Here the tenant is providing an indemnity to the owner arising out of any loss or damage he or she may suffer by renting the unit, and the loss is specifically including any personal property in the unit and or claim for damages as a result of property being stolen, damaged by fire, or other casualty. So here the purpose again is that the owner faces no liability for the destruction or loss of personal property of the tenant. So please ensure you get your own insurance. Certain things in the lease require that one party provide notice to the other. So for example, some leases will renew automatically and require that you provide notice no less than 30 days before, meaning notice must be given more than 30 days before the event is supposed to occur. Others provide notice is supposed to be provided no less than 30 days, meaning it can't be more than 30 days, it must be less than 30 days. Nonetheless, notice is rarely acceptable to simply be verbal. The whole concept here is providing instructions on what is proper notice. Here it specifically states that it can be registered or certified mail. Basically, either one provides proof that mailing occurred. Now, this is a sophisticated contract, but simply writing a letter and keeping a copy and leaving it at the owner's mailbox or mailing it to them should be sufficient. Just make sure that you know whether your lease renews automatically or if your lease includes a clause that you can renew if you provide notice, or any other sort of condition to which you have to comply with. In addition to what specifically is mentioned in the lease, the tenant agrees to comply with other regulations regarding safety, health, and the security for the property, which simply means municipal, city, state, or local ordinances that apply to the landlord-tenant relationship. Here you see that parking is prohibited, no pets are allowed. The next section states that if repairs are needed, the leasee or tenant shall notify the owner so that repairs can be made. The right to entry is always a cause for concern. Landlords do have access to see the tenant's property, but here it requires advance notice. So advance notice usually is acceptable to mean at least 24 hours before. The exception to advance notice is obviously if the tenant's there and just simply grants access, or in the alternative, only under emergency circumstances can the owner enter the property without actually having received direct consent from the tenant. But that is an issue left to be resolved. So was the cause for entry an emergency? If there's justifiable cause, then the answer is yes. I mean, if there's smoke coming, excessive noise, something that will likely lead to for a normal person to think we are under an emergency and not simply because I'm curious or not simply because I cannot wait. For any serious violation of the lease, it requires 7-day notice to vacate on behalf of the owner to tenant. So it would have to be a serious security or lease violation for this clause to apply, because it implies the possibility that you could be kicked out within 7 days. On the other end, if it's due to non-payment of rent, it provides 14 days notice to quit. Even though it's either 7 or 14, in most states, an owner cannot kick out a tenant. Now, this is specific to state law, so you'd have to look into what the rules apply to you. But here in Massachusetts, a 14 days notice to quit After the 14-day period passes and no payment has been made, it simply opens the window for the owner to pursue a complaint in court for an eviction. The standard turnaround for getting a hearing is still roughly 3 weeks later, so people complain that the process is slow. The best thing that a tenant or an owner can do is simply inform themselves of what the legal process is, so that rather than trying to figure it out in a time of need, you're well aware of the time frame that you'd face. If a tenant breaches a lease, according to the contract, they owe the rent for the rest of the lease period. But courts have found that to be unjustifiable, especially if you breached it the first month of a 12-month lease, meaning it does not make sense that an owner leave the property vacant 12 months simply for the purposes of collecting damages from this tenant that already breached it. So the language in the contract is that you owe the full term, but realistically and logically, the rule the court will generally apply is that a tenant will be liable for damages to the owner for rent loss up to when they rent it again, plus all losses directly related to the breach. So it can include advertising expenses, broker fee, cleaning fee, lock fee, and even attorney's fees if it was necessary to pursue a legal action. So nobody wants to deal with this, but it's good to be familiar with local rules and law about what damages would be permitted if you breached, simply to understand what the consequences are if you're getting into an agreement that might be costly if you fail to keep your part of the bargain. When an eviction occurs, the owner is given the right to get movers to remove all the personal property out of the apartment and take it into storage. The owner has to pay even though the tenant will be liable for those damages. Removal of goods here simply states that if there's a court order for eviction, the owner will not be responsible for any damages to the tenant for the value of the property that is taken. Of course, damages can be claimed if the owner removed the property without court order. Non-surrender simply means that the owner will not accept the delivery of the keys or that you told him the apartment's empty as surrender and termination of the lease. The theory is you still owe the rent until you both reach an agreement in writing or you get an agreement about what the damages are that the owner will seek from you for violating the lease. Subletting is when you bring in additional people into your unit. It is generally prohibited, and the lease normally states unless the owner provides written consent in writing. Trustee, it's just a clause stating that if the contract was signed in a fiduciary capacity on behalf of a company or entity, the individual themselves are not personally liable for the terms and conditions in the lease. Waiver clause. In simple terms, it means that if the owner fails to enforce a particular clause, it is not a waiver of the term for the rest of the period and can still be enforced at a future time. Severability clause simply states that if for any reason any clause in the contract is found to be unlawful, improper, or illegal and cannot be enforced, the remaining contract terms and conditions can still be enforced, and only the unlawful or unenforceable part will be omitted. Copy of lease simply states that the owner and tenant both have received a copy of the lease or will receive one after it is signed. Reprisal simply states that landlord cannot take any action against the tenant for their right to enforce or assert legal rights granted to them by state, municipal, or city law. Other provisions is simply a section where you could add in any terms that you want. So here, because the rent was $24,000 a year divided into 12 months, it's $2 a month. There was no mention of getting a security deposit or last month's rent. So I went ahead and included that the tenant has paid security deposit and the tenant has paid last month's rent, and the signing would confirm that. Alternatively, you want to make sure that you get receipts for those payments, as the landlord is obligated to provide them to you, but some fail to do so. Many leases where the tenant does not have great credit but still manages to get a lease will have a section for a guarantee. A guarantee is simply an additional party that agrees to be bound to the financial obligations of the lease, but not to the terms of actual use and possession of the apartment. So generally, a college student, for example, might rent an apartment that they agree to pay and use the property, and a parent might be the one designated as a guarantee or security for the apartment lease.